Hello and welcome everyone to another Your Strata Property live broadcast. I am Amanda Farmer and I am the founder of Your Strata Property, where we are simplifying the legal complexities of apartment living so you can live more peacefully and profitably in your apartment. And very shortly, I am going to welcome Reena Van Aalst, the owner of Strata Central, a strata management company in Sydney. But before I do that, I want to make sure you know that the replay of the Better Buildings webinar is available on this page. The webinar was conducted by me yesterday. It is all about how a properly functioning strata committee can dramatically improve your experience of apartment living. So you'll find that webinar as a live video stored on this page. Just go and have a little poke around. And we had an awesome time on the webinar yesterday, lots and lots of questions, and that is why we are back here today. I didn't get time to answer all of your questions, and together with Reena, I'm hoping that we can get through a few more because they are important questions, and I want to make sure that you all have the information that you need to dramatically improve your experience of apartment living. Plus, if you are joining us live today, please do pop a question in the comments section below this video. We will do our absolute best to get to as many questions as we can today. The other thing that I want to make sure you know about is this: the doors to the Your Strata Property membership are officially open. I announced this on the webinar yesterday. The membership is usually closed to new members, and I only open it up on very special occasions, and this is one of them. Members enjoy access to a Q&A forum where they can have their strata questions answered by me and my team of experts, people who are just like Reena, who know what it is that they're doing when it comes to strata and strata law. Members also have access to a growing templates library, and those templates include template bylaws. These templates are otherwise for sale on the website, but if you are a member, you get access to all of the templates, all of the ebooks, past webinars, absolutely free. So to find out more about membership, you want to head over to yourstrataproperty.com.au/membership. And I think my colleague Michelle, if she is there, is going to pop that link in the comment section for you. But be quick. The membership doors will be closing again at midnight this Sunday, the 31st of March. So you really do need to be getting in before then. Okay, now I am using a different software today to conduct this Facebook Live. So please forgive me if I'm a little bit jumping around on different screens. I'm just getting used to it. If you're coming in, please pop me a little hi, hello in the comment section so I know that you are seeing this video and everybody can hear me and it's all working well. I'm just looking at my other screen so that I can also see your name when your comments come up, because I can't always see the names on this app that I'm using here. So what I am going to do now, it's looking like all that's coming through, which is awesome. What I'm going to do now is welcome in Reena Van Aalst. So if I press this button here, let's see what happens. There she is. Hello, Reena.
Hello, Amanda. How are you?
I'm doing very well, thank you. How are you today?
Wonderful. And I want to thank you very much for inviting me to be a guest on your Facebook Live feed today. It's our first one together, so I'm very, very excited about that.
It is indeed. It is our first live broadcast. We, of course, do the podcast together regularly. The podcast has been running for 3 years, and I think 2 of those years, Reena, you have been my co-host every second week, where we talk about our wins and challenges in strata.
Exactly. So I'm really excited, Amanda, about getting some questions and some feedback from your members today.
Yeah, absolutely. So I've invited you here, Reena. I know you were attending on the webinar yesterday. And as an experienced strata manager, where I thought we might start is to get your key takeaways. So what were the things that stood out to you in the webinar content that you wanted to highlight for those watching, and maybe we could get stuck into in a bit more detail?
Yeah, so there were probably three takeaways that I got yesterday, Amanda, from the webinar. The first one would be the actual role of the Strata Committee, and in a sense, in the cases that we were listening, we saw questions relating to were dysfunctionality, lack of transparency, people not understanding how decisions were being made, and obviously the personality types that are on committees, and sometimes how some committees don't function properly. The second thing would be how committees are constituted, who's eligible, what to do if there's a vacancy, how do you get people to be on a committee, the numbers, etc. So I think that how committees are constituted and how they work, who can fill a vacancy, all those sorts of things I thought were one of the areas that people perhaps weren't sure of. And in my experience, even strata managers sometimes don't understand this area of the Act either. And the final one, I think, would be the role of the building manager. Again, what their role is, their involvement in running the scheme, the politics, I think, that may occur with building managers getting involved with certain committees and that sort of dynamic. And also there was a comment, I think, about issuing work orders and not have a building manager not actually doing that. There's no copies of work orders. Therefore, a treasurer was unable to approve invoices because there were no work orders issued against any of the invoices that he had to approve. So again, I think there's a common theme of lack of transparency, lack of information, and people sort of not feeling empowered in their own buildings and their own homes.
Which is really disappointing to hear that's how people are feeling in their own homes and not quite sure where to go to fix that. You mentioned there, Reena, personalities, and I did see that come up a couple of times in the chat box of people saying, well, you know, Amanda, we're following the procedures, we've got the legal process in place, but we just have a difficult person on the committee. Now, you work with committees every day, Reena. When you have these difficult people, how do you deal with them?
I mean, it's not easy because you have to basically understand sort of the intentions of that person, and that to me is always the first indicator of how I will deal with them. So if it's a person who is trying to do the best for the building but just has a sort of controlling personality, then I sort of approach it one way. And when that occurs, I try and involve the other committee members as well so that we have a full and frank discussion if there are things that aren't occurring correctly. I saw a strata managers sort of asking that question about whether or not how do you try and deal with a committee that doesn't actually follow the law. So that's one area I think you can actually work on in terms of actually having a face-to-face meeting with all the members of the committee and that controlling person to try and diffuse or bring to light the fact that there are sort of some anomalies in how things should be undertaken. If the person is on the strata committee for their own benefit, and this is probably the more prevalent one, I think, in some cases where there's dysfunctionality, then in a sense you've got to try and make sure that you come back to the law, because usually those people want to do things for themselves and they want to take shortcuts in order to do that. In one particular case that I've had where I sort of called somebody out, they don't even email me anymore. Somebody else on the committee does. So I don't know what's happening in the background, but sometimes, you know, when you call people out, they don't like it and they sort of then don't want to communicate with you, which I think is fine. So I think you've got to really understand the building, the intentions of the person who's on there. And I think when you were talking about the best number, Amanda, being, you know, between 3 and 5 members, sometimes you may need to, encourage other people to get more involved at the AGM and perhaps not elect that person on the committee. I mean, that is sort of the ultimate goal for people to try and get rid of someone. But on the other hand, those people have to sort of step up and do the work, because sometimes those people that are controlling are the only ones that actually will do anything.
Yes.
And other committee members just either, it could be because they feel intimidated, it could be because they don't have time. But in a sense, if you do want to have a very well-functioning strata committee, everyone's got different talents, everyone's got different skills, everyone's got different strengths and weaknesses. So as long as a committee on the whole, you all work together and achieve the outcomes that you're trying to for the year that you're on as committee members, then that's fine. But in a sense, sometimes you get rid of the controlling person and then nothing gets done. So so in a sense, you sort of be involved, not just try and get rid of people, but be involved when you are on the STRATA committee.
Be ready to roll up your sleeves, and if you do want to affect real change, it might take some work. Now, I'm glad you answered there. I think it was Christina, who is a STRATA manager, who asked that question about how do we deal with committees who are not following the law. And we also talked about that, Reena, in a podcast episode. I think it was maybe 2 weeks ago that one came out, where you celebrated a win, and that win was, I fired a building. I fired a difficult building. And I think that's important for any STRATA managers to understand. I think if your committee is refusing to comply with the legislation, to follow your advice, then you need to sit down and have that hard talk with them and say, look, I cannot carry out my functions in accordance with the law unless I have your instructions, or I cannot do these things that you are instructing me to do because they are illegal, and not to be afraid to do that. And as you said, Reena, you've had those hard conversations, and then people have either come into line, or the difficult person goes off the committee or stops communicating with you, and that solves your problem.
Yeah, exactly. Another part of that, I think that question also, Amanda, is documenting that we have provided the correct information on the minutes of meetings sufficient to protect ourselves. I think that is definitely a step you need to undertake. You need to basically minute that, let's say they decide to do X, and then you need to put like a note, so the managing agent advised that this is contrary to the act, or whatever the subject is, and how you need to sort of minute it. The other thing also is to send emails. So basically, as an agent, even if sometimes it may not happen in a meeting situation or scenario, so you can't minute it as such, but you need to sort of write an email and say, this is what I did with this particular person, that basically I gave a whole chronology of what had happened, and I said that he asked me to pay a deposit for a contract for window replacement. I had a chat with him on this day. I advised him that you needed to have the Home Building Compensation Fund insurance policy in place before you pay any money. He said that basically the contractor had told him that I didn't know what I was doing, and that I was no better than their previous STRATA manager. And so I sort of tried to be polite and say, maybe, he was saying those things. But, I said, I will not be signing any contract until that insurance is undertaken. So, and I put a whole chronology, which is obviously, didn't fare well for him. But at the end of the day, I'm here to act for the Owners Corporation. And if the STRATA committee, in that case, nothing has ever happened since. They haven't paid the deposit, and I think that the whole thing has been put on the shelf for the time being. But I just believe that you need to articulate and sometimes copy in the other members. So if it's a one-way conversation with that person, you may then need to copy in all members to make sure that they understand why you can't do what someone's asking you to do, or it could be all of them are asking you to do it.
Yeah, really important. I am just looking at all of you coming in and saying hi. Thank you for being here. Hi, Dilshani. How are you? And we've got a question in the comments box here from Bruce. Hi, Bruce. And Bruce is interested in our thoughts on having a building management system to ensure that record keeping is accurate. What do you see your buildings using, Reena? I know there's probably a difference between your STRATA management sort of record keeping software, and then there are these fancy platforms for building management for these larger schemes that have lots of different things going on. What do you think about software?
Yeah, I believe it's a very good idea to have a building management system, but to have a non-proprietary one, because some building management companies use their own software, and then if they are terminated in the future, then that sort of data is going to be difficult to be exported into another system. And so it's best to use, I think there's, at the moment that I'm aware of, the two main ones are Building Link and MyBoss, which obviously are platforms that are based on the cloud, and then people can actually residents can email the building manager. I also sometimes find that the building manager need to use them properly. So if you don't use them properly, if you don't enter all the data into the system, if you don't actually issue work orders from the system, then pretty much it's a waste of money. So I think these platforms are great as long as and sometimes like we're asked to actually upload minutes onto those platforms as well, which is fine, so that people can get the minutes from us. Obviously we can't use that as a method of service under the Act, but it's obviously another way of providing minutes, so owners can access them via this platform. So I do believe they're a good idea to have, as long as use a non-proprietary product, use a common brand that you can sort of then, if you move building management companies, you can still retain all the data and then use it with a new building manager.
Sounds like good advice to me. While we're on the subject of building managers, we did have a question on the webinar, which I didn't get to, and it's a really good one from Barbara. And Barbara asked two things. First of all, can a building manager be on the committee if the building manager is one of your employees? Do you want to answer this one, Reena?
I'll let you answer that one, Amanda. I think we had a discussion, so I'll let you answer that one.
Yeah. Well, in New South Wales, Barbara, we do have a section in our Act, which is Section 32, which expressly sets out the people who are not eligible to be appointed or elected to the committee. And building managers are not eligible unless they are also the owners of lots in the scheme. So if your building manager is not also an owner, then cannot sit on the committee. The same applies for leasing agents. So people who are the agent who let the lots, unless they themselves, of course, are an owner in the scheme, then they cannot be on the committee. The same applies to anyone connected with the developer, so who we would call the original owner of the scheme. If they're connected with the developer, not an owner, they're not able to sit on the committee. So Section 32 in our Strata Schemes Management Act is a good place to go and have a look at those eligibility requirements. And as I mentioned on the webinar, Section 31 is the section that sets out who is eligible to be on the committee. Ever been in that situation, Reena, where you've had to say, no, you are not allowed to come on this committee?
For a building manager and a leasing manager, no. I have had them on committees in the past because we've actually had them own lots. So sometimes, historically, Amanda, under the old agreements, they used to sort of own a lot, so they could actually then be able to, vote or to have a space for their offices. But I've had a leasing agent that was on a committee previously, and she actually took quite a political role because usually with new schemes, the selling agent becomes the leasing agent for most of the investment owners, because they obviously develop a relationship through the sale. And this particular person actually ended up getting Australian Management Company terminated. So, but now she couldn't be on the committee anymore, so that wouldn't have happened, and she would have had less influence. So, yeah.
So that's under our old laws in New South Wales? Yeah. So we had our new laws that started in November 2016, 2.5 years already. You can believe it. Just to finish off Barbara's question, the other thing that she asked was whether non-committee members can attend meetings, attend committee meetings, I should say.
Yeah, so the Act does allow owners to attend meetings, but they can only sort of they're only allowed to speak if the committee allows them to do so. So the committee has to resolve to allow them to do so. And in most cases, I mean, I had a meeting last night and there was more actually owners present than there were committee members. And there's nothing contentious. People like to sort of come and ask questions. And I think that's a very healthy sort of thing to do if people are genuinely interested. Although sometimes people do come to express their own view in a very, non-democratic way. But anyway, they don't occur as much. But sometimes some owners may use that as a platform to try and get a message across or their own message across. So, but that's why the Act says that the chairperson and the committee have the authority to let them speak or not speak. So
that's a really good reminder. Good little tip to have up your sleeve then. Dilshani is asking a question, just going back to strata managers. How do you handle a strata manager who doesn't help with issues and problems in a timely manner, doesn't call you back? The owners have had enough with the manager. Well, Dilshani, I would say time to go and seek quotes for a new manager, someone who is perhaps more professional and more responsive. You'd want to have a look at your contract though and see what the term of your contract is with your agent and what the terms of termination are. So is there any provision there for early termination? And I would be looking at what the duties of the strata managing agent are, and are they failing to carry out any of those duties? And you can sit down with them and say, hey, you're supposed to be doing A, B, and C. You're not doing A, B, and C. We have grounds to terminate. We really don't want to, but we will if you are not properly performing. So having that hard conversation.
Another thing to do, Amanda, if the agreement still has some time to go, is to actually confer with the person's superior, the licensee in charge, or whoever that person reports to, and perhaps bring it to their attention. Because sometimes, the owner of the business or the person that's the general manager may not be aware of these issues, and so sometimes that may be remedied that way, or they may assign you with a different strata manager. So that's another option that you can take.
Yeah, really good point. In those larger companies, there might be someone else who's a better personality fit for you and for your building. Michelle, hi, how are you? She's just popped in the comments section there that she has trialed Strata Box in terms of building management software, and she liked that. Michelle is a Strata manager. She's not linked to any particular building manager, but she's trialed Strata Box. Heather, hi, how are you, Heather? What would be our advice if the building manager is appointed as treasurer? Okay, so this is where I'm going to assume, Heather, the building manager is an owner. They are on the committee. They are then appointed as treasurer. So I guess you're saying they then have the duty of approving invoices. That's kind of the limited duties that treasurers have. And is that then a conflict of interest because they're approving their own invoices? I'm going to assume that's where you're coming from, Heather, but feel free to pop another comment in. Reena, what do you think? A conflict of interest having?
Well, normally in buildings, the building manager does give the approval for the invoices to be paid because they're the actual ones that know if the work's been done. So a lot of the time, the treasurer and the building manager sit together. The treasurer will sign off on the invoice, but the building manager is the one that actually has given the authority normally for the invoice to be paid.
Got it.
In terms of, so that's that function. But when the actual person is a treasurer and they are also issuing the work orders, there's no sort of separation of like duties in a sense, because it's like, say, in a company, the person who's issuing, like a purchase order is then sort of paying it as well. So there's lack of sort of, not the transparency, but a separation of duties where, sometimes in companies, this is where things go wrong when you don't have a middle person or a different person doing different parts. Being a treasurer, I've never actually ever seen that before. But perhaps maybe to allay any, conflict sort of concerns. Maybe
appearance of conflict.
Appearance. Maybe a second person could also co-sign or co-approve invoices, if that sort of helps to sort of make sure that there's a sort of an arm's length approval process, and allay any perceptions of conflict, whether they are in fact conflicts or not.
Yep. Excellent. That sounds like very practical advice there. Thank you, Reena, and thank you, Heather, for that question. I'm just heading over to our list of questions on the webinar as well, a few things that we didn't get to. Reena, we talked a bit on the webinar about decision-making of committees via email. And I think I was quite passionate on the webinar about the fact that our committee should not be making decisions over email. Get off the email. You need to be having formal, legally compliant committee meetings. And I know Janet posted a question. The committee decisions happen, she says, via email 90% of the times. What if they minute their email decisions and post them on the notice board? Is that okay?
Well, unfortunately, no, because it doesn't actually comply with the statutory provisions. And secondly, the Act is quite clear that you need to basically make decisions through meetings. Now, unfortunately, you couldn't have a meeting every week because there's so much happening in some schemes. But I think, as you mentioned, Amanda, you can obviously make decisions in between if you really have to, if it can't wait to the next meeting, and then you can ratify it and confirm it so the owners are aware that something has already taken place. But the problem, I think, also that I find is that if you don't keep a record of all the things that you've been doing, then how are you going to ratify them? So for us, when we're putting together an agenda, every single email that comes in that relates to something that has to be on the agenda, we have to put in a separate folder so that when the meeting, we're drafting the agenda, we actually have a record of all the stuff that needs to be put on and all things that have been done that have to be ratified. So and I think things like minor expenditure, I don't believe you have to sort of, write down you bought a notice board for $200. I mean, to me, that's not really the intention. We're talking about, things that are important, that, are significant, that, people would be interested in knowing about. Expenditure, say, of sort of maybe 2,000 or 3,000 upwards should really be minuted, I believe, because, you have 10 of those and that's, 20, 30,000. And it also gives people understanding what the committee is actually doing. So like when you produce minutes, I mean, we have agendas that are 4 pages long with all the, motions and all the correspondence, and we have the financials, so that people can see that the committee have been doing a lot of work, so which people would not see because it's all being done by email.
That's
the other
right.
thing I think you mentioned, Amanda, too, was the fact that, like people don't want to have a strata manager there because they don't believe that they add value and they don't want to pay the cost. But as you said, a good strata manager will save you lots of money because in a sense, they'll make sure that you do the right thing. And even buildings that are experienced, the experienced committee members and people that have done it for many years still don't know everything in terms of the law. And therefore, a good strata manager will help you and guide you and also make sure that you are minuting things correctly, and that things that should be put in the minutes are, and things that shouldn't be. Like I think you mentioned certain things, if there's legal matters, you don't want, if there's any issues that are quite sensitive, you've got to think about whether they are put in or not. So a good strata manager will save you money in the long run and tell you how to do things, so that later on, if something does go wrong, the committee can't, well, the manager was there, they helped us, they had the minutes ready for us. If someone wants to say the committee is not acting properly, your manager has ensured that you've got the evidence there. Whereas if you do things without the manager there and you don't know what you're doing, then next minute an owner may have a legitimate claim against a strata committee.
I often say, not so much in the context of getting strata managers involved, but certainly getting lawyers involved. If you've got a lawyer there who's guiding you, giving you advice, you got someone to blame when it all goes wrong. So
yeah. Yeah,
if you want to think of it that way, our strata manager told us to. I'm not by any means suggesting, committee members, that you go and blame your strata manager, but having that professional there and following their advice does give you a level of protection. It does.
Yeah. But I do think, Amanda, that some people don't feel that their strata managers are giving them that advice, which I think sometimes is why they don't believe that they should be there. And so it's sort of paying for someone just to be like a minute taker, which is of no real value. Yeah.
That's a very good point. Yeah. It's about strata managers being able to show their value so that you feel like, we absolutely want that person at the meeting and they're worth the few $100s that they're charging.
Yeah. Exactly.
I'm just seeing Layla. Hi, Layla. Thanks for coming in. Saying that the Act, of course, does not mandate that committee meetings have to occur. You're exactly right, Layla. It does not. And that is a confusion. I think that's where this culture of not having meetings kind of comes from. I think, well, it doesn't say we have to have an annual general committee meeting. It says we have to have a general meeting. The way that I see it is the committee is not otherwise empowered to be making decisions, especially about these serious issues of expenditure, like you say, Reena, a few thousands of dollars, unless they're in the context of a committee meeting. We have a whole Schedule 2 to our Act, which is devoted to telling committees how to make decisions. That schedule wouldn't be there if we weren't supposed to be making decisions in committee.
But you're right, Amanda, there is a disconnect between the fact that there is no mandated amount of meetings to be held versus the concept of saying that you can only make decisions by meetings. So that's something where the disconnect has occurred, where people haven't sort of put 2 and 2 together. Like an AGM, everyone knows you have to have an AGM because it's mandated one AGM a year, etc. Yeah. Whereas committee meetings, because there's no such reference to a specific number or time period that they have to occur in, that people disassociate the function of making decisions away from the concept of having a meeting.
And maybe that's a job for our legislators to really think about that in the next redraft or amendment of our legislation. As far as I'm aware, and I'm sure our listeners, our followers, our members will let us know, there is no provision in other jurisdictions that mandate minimum numbers of committee meetings, but I think it's a great idea. I think at least once a quarter. I know some of you to be saying, oh, but we're in a 4-lot scheme. We're all on the committee. We're all owners.
And nothing happens.
Nothing happens. Look, there can be carve-outs and exemptions for that kind of thing. But it's very easy to hold a meeting in writing, and you don't actually have to, if you're a small scheme, there's not much going on, to issue a meeting notice in writing. And on that point, I think we did have a question on the webinar about what do we mean by a meeting in writing. That is in Schedule 2. Is it Clause 9, Reena?
Clause 9, yeah, it is Clause 9,
Clause 9. Sometimes you'll hear your strata manager call it a Clause 9 meeting. A committee can have a meeting in writing, which is just, well, you let us know, Reena. You're the strata manager. You'll be doing these regularly.
So basically, what happens with a strata committee meeting held in writing is that the agenda can only be motions that you can say yes or no to. So it can't be anything that requires a discussion. So it's approval of quotes, it's approval of an application by an owner to have a pet, those types of motions. And then there's a voting paper that basically accompanies the agenda to say you either vote yes or no, either for or against that particular motion. And then you sign the actual voting paper, and it's kept as a record. So that's how the record is kept of the votes. And it's like a real meeting in a sense, is that instead of like being there and saying yes, you're saying yes. So an agenda must go out at least 3 business days before the meeting. The voting papers have to be in before the date of the meeting. And so it's the same sort of concept, because the meeting is being held at a certain time. So the agenda will say a meeting in writing will be held on, Monday, the 1st of April at 3 o'clock. And the agenda went out at least 3 days beforehand. Those voting papers must be in by 1 o'clock on Monday the 1st.
Yep, perfect. Excellent. Now, we had a question on the webinar from Ronnie who said, is there any way to be elected onto the committee other than being elected at the AGM? Go ahead.
Yes. Well, yes, there is. As I think Amanda and I have discussed before, only if there's a vacancy. So the number is set at the AGM, and that number is set until the next AGM and can't be varied. But if someone has resigned, they've sold their lot, or I think there are a few other things, Amanda, in the Act that talk about, in a sense, how people end up coming off the committee. I mean, in the worst case scenario, is if there's a general meeting held to actually remove someone off the committee, and that's by special resolution. So that's another way you can get on. It hasn't happened very often, but it has happened. But the other thing that's now in this new legislation that wasn't in the old one is that the committee may fill the vacancy. They don't have to. And that's come up, I think, in one of our podcasts, Amanda.
Yeah, and I did talk about that yesterday as well. If you don't fill the vacancy and you've got a small committee, you could run into problems when it comes to your quorum and making sure that you have a sufficient number of people present at each committee meeting in order to go ahead. Because you do need a quorum, unlike a general meeting where if you don't have a quorum, you can just go ahead anyway. You do need a quorum for a committee meeting, and the quorum is the majority of committee members based on the number elected at the annual general meeting. So if you've had a few people resign, you got vacancies, it can be hard to get a quorum.
Yeah, exactly.
All right, I'm just looking at our list of questions from the webinar here. We did have a question from Alex. If there's a quorum at the start of the committee meeting, but somebody leaves, does the meeting need to stop or can it continue? Will the voting afterwards still be valid? Now, that is a very good question, Alex, and I am, as I always have my Act handy. I know with general meetings, Reena, when it comes to quorum, it's whether there's a quorum for each motion. It's actually not a quorum for the meeting. It's a quorum is required for each motion. And I'm just looking.
The same applies to committee meetings as well.
Excellent. Yep. Wonderful. I have just found that, Alex, clause 12 of Schedule 2 to the Act. Yeah, it is the same as for general meetings. A quorum is required for each motion. So yeah, if somebody leaves and you no longer have a quorum, then you've got to stop the meeting for lack of quorum.
Yeah, and I've actually had that happen where we don't have a quorum anymore and we can't continue. So the meeting, can be those motions can then be considered at the next meeting, but that meeting has to end at the motion where that person left.
That's it. Pauline has said that she is on the committee of a large strata scheme. It's 120 lots. So how far in advance do large strata schemes have to provide notice of their meetings? Well, as far as I'm aware, Pauline.
Yeah, it's the same. It's at least 3 business days, but because everyone has to get a copy of the agenda, it means that you've got to take into account the the postage criteria for those that don't have email. So if everyone had email, then we'd all be happy, but unfortunately that's not the case. So you've got to go back to the Interpretations Act now, and it's nearly, I think, nearly 10 days beforehand.
It's now 7. We had a change to our Interpretations Act in New South Wales. Postage used to be deemed received after 4 working days. It's now 7 working days. That was a change earlier, towards the end of last year, maybe November.
Yeah, end of last year, yeah.
Yeah. So you're exactly right. It's still the requirement to have 3 days notice before a committee meeting is the same, whether you're large or small. But remember, in large buildings, as opposed to small, you have to give each owner notice of the meeting. So if those notices are going out by post, as Reena says, you've got to bear in mind your 7 working days. So I'd be thinking 2 weeks, you've got to be sending those out by post.
Exactly. That's what it becomes. Sometimes it could even be more, Amanda, because it depends on the day. Then if it's a weekend and there's a public holiday, and so it can, like,
exactly.
If it was like Easter this time, or let's say you've got Easter and you've got Good Friday, you've got Easter Monday, and then you've got Anzac Day. So if your meeting was like, after that, you've got to give more time notice.
Yeah. Bear that in mind, strata managers. Easter is coming up, and there's quite a few public holidays in that week. So just be aware of that with your agendas going out. Layla's just saying, does it need to go in the post? Can you drop it in the letterbox? Absolutely. You can hand deliver them. So whatever your delivery method is, of course, if you're hand delivering it, then it's deemed same day delivery. You have to be able to prove that though. So just make sure, what record are you keeping to prove that it was hand delivered? I'd be, ever the lawyer, I'd be taking a photograph or a video. I am putting this in the letterbox. This is my video. The notice going in the letterbox of apartment 2. Postage, you might have a register if you're a strata manager of postage that's going out. If you're doing registered post or express post, you've got the tracking as well. And of course, emails, you've got your sent email to prove that it has gone.
Exactly.
Okay, I'm just having a look through these other webinar questions. A few of the same questions.
There's one, Amanda, that I noticed yesterday was that, can you nominate yourself, or does someone have to nominate you? And that's probably a very common one that I find that people ask at general meetings at the AGM when they're obviously being elected on the Strata Committee. And so what I keep telling, I use an analogy because people sometimes get confused when you try and be too technical, because the Act is when you're reading the Act out, it is a bit confusing. So the way that I tell people is that, like, if you own something in your own name, you can do whatever you want with it. You can sell it, you can, lease it, you don't have to ask anyone, and you can nominate yourself on the committee. But if you're owning it with your partner or husband or wife or somebody else, obviously, the decision isn't just about you. You got someone else to confer with. And in that case, you can't nominate yourself. They have to nominate you. So I try and use that as an analogy to try and make people understand why they can't nominate themselves if they're a co-owner.
Good one. Yeah, it is complicated, the whole process around who can, who can't, especially if there's co-owners involved. But yes, if you're an owner, a sole owner can certainly nominate themselves.
And then you've got the added complication, sorry, Amanda, about, companies. So, the company nominee, the person that turns up, who represents a company, unless the company nominee is on the strata roll, they can't nominate themselves either, because a company is not a person, and we have to know in writing on the roll, which means before the meeting, who the company has appointed to represent it. So that's another thing that's happened, where people haven't been able to get on the committee when the lot's owned by a company.
Joy of joys, don't we love all these complications? Can subcommittees, this is from Suzanne from the webinar, can subcommittees make decisions that are then ratified by the committee at their next meeting?
Yeah, I saw that question. And
it's creative.
Well, I mean, to me, the subcommittee can only make recommendations, which the committee can then ratify or not, but they really can't make any decisions as such. So they can put forward their recommendation, and that gets put on the agenda as a motion, and then it gets either adopted or it gets rejected.
Yeah, I like that framework, Reena. A subcommittee can make recommendations, and then it's a matter for the committee. Yeah, good one. Being on the committee is a lot of work. Do committee members get remunerated for all of this work, or is it voluntary?
Yeah, well, it's a very good question, which I think a lot of people aren't aware of, but there is a provision in the Act to put on the AGM agenda a request for an honorarium to be paid to a committee member for the preceding year. So if your AGM is going to be held like in April this year, then it's obviously for the work they've done in the last 12 months. So, and I've got actually a few buildings where they have an honorarium, which has been actually at my instigation, because a lot of people actually do so much work, which in a sense saves the building so much money, because if we were having to do it, we'd have to charge for it. Obviously, they're doing it in their own time and, putting so much effort, and, they meet with contractors and companies, and they, a lot of people also go to seminars and they really try and educate themselves as well when they're on the committee. And to me, people's time, has a value, and even if you're not working, and because you could be doing other things, and therefore I think there should be an honorarium in place when someone does above and beyond what they should be doing, and other owners are also benefiting from that. That's the thing, like what they're doing doesn't just benefit themselves, but everyone obtains a benefit. So to me, they should be remunerated, and I think obviously you have to make sure as a manager that you've made an allowance in the budget for it, whether it passes or not. But at least you can't just then have it on there but not have the budgetary allocation to show that you have put some money aside based on what you're proposing in the motion for the honorarium amount.
Yeah, very good advice. And I have just looked up, it is section 46 of the Strata Schemes Management Act in New South Wales that says that an owners corporation may pay to a person who is either an office holder, so a chairperson, secretary or treasurer, or another member of the Strata Committee, an amount determined by the owners corporation at an annual general meeting in recognition of services performed by the person for the owners corporation in the period since the last annual general meeting. So that's what you were saying, Reena, the preceding period. Yeah. So that's section 46. Yeah, a good one there to be aware of. Can a strata manager refuse to include a motion from an owner on an AGM and just tell the owner later, no, didn't want to include that motion on the agenda?
No, unfortunately, the strata manager doesn't have that authority. Even if the motion's invalid or it's illegal or whatever, then the chairperson at the meeting will then rule that out of order if necessary. But the strata manager doesn't have that authority, and I doubt that their agency agreement would even go that far in terms of, it's against law anyway, so it couldn't really do that. And before you had to be financial to submit a motion on an agenda, but now you don't have to be. With the new legislation that came in at the end of November, that requirement's been removed. However, at the meeting, that person then has to be then financial to be able to vote. So it still doesn't take away that aspect of it. Yeah, so it's important for owners to be aware of the requirements for submitting motions to annual general meeting or general meeting agendas, because if you don't comply with those requirements, your motion might be ruled out of order by the chair at the meeting. So, of course, you have to get your motion in before the agenda is finalized and issued. Exactly. And this is a really big bugbear, I find, for owners. And I see it come up in the members forum, people saying, I want to get a motion on, but I thought the annual general meeting was going to be in September. And then all of a sudden I've got the agenda in the mail and it's happening in August, and I've missed my opportunity to get the motion on. So isn't there an obligation for owners corporations, for strata managers, to tell us when the general meeting is going to be held and when the notice is going out? Well, the answer is no. They don't actually have to give you the opportunity to get a motion on the agenda. You can have that ambush kind of general meeting situation, which I know happens and is really, really frustrating. So what I recommend to owners who have an issue that they really want to have considered at the general meeting, whether it's a bylaw they want to put forward for a renovation, that's often the case, or whether it's just a particular issue that they want to have addressed about repairs and maintenance, put that motion in to your secretary via the strata manager if you've got one, as soon as you know you want to put it on. So even if you're 6 months away from a potential annual general meeting, that way you will not miss the boat. And the other thing you have to remember is to submit it with your explanatory note. So in New South Wales, you have to issue lot owners must supply motions with explanatory notes of no more than, get that right. No more than 300 words. So your explanatory note just says what this motion is about. So this is a motion submitted by the owner of lot 2 for the following reasons. I want to renovate my bathroom because it's going to look nice. I want a nice bathroom.
something
Yeah,
like
sometimes, Amanda, we get people asking us to draft the motion for them. And as an agent, we really can't do that. I mean, we try and guide them and say, you got to say that, and you look at some other motions and say what you want to say. But sometimes people get upset that, we can't draft it for them. And it's not really our role to act for individual owners. I mean, definitely we help them and we try and give them examples of other motions, but don't expect your strata managing agent to draft it for you.
that. Yes, indeed, or fix it for you.
Mm.
Do we recommend private Facebook groups for buildings, Reena? Have you been involved in any buildings that have set up a Facebook group?
Yeah, I have been. And usually it becomes a forum where I think people can make some terrible remarks about other people. And unfortunately, they sort of forget that, it's not your friends that you're dealing with, or, I mean, I don't know what people say about their friends on Facebook, but I find that it can become a platform for a lot of aggressive and unsavory communications. And it can be used to galvanize people against certain other people. Unfortunately, I haven't seen it being used in a productive way, but that doesn't mean that there aren't great Facebook, groups out there that do function well. But then again, I suppose in a sense, how does Facebook, if there's something that's being said, and should it be part of the records? I don't know. I mean, how does Facebook then, if people are communicating by Facebook, then how does that get onto the records of the owners corporation when they're having these, like it's like people on Building Link or any other platform, that building management systems, how does that request come onto the records of the owners corporation? Because it's not really deemed to be a legal way of communicating in terms of what's recognised under the owners corporation and their records and how they're supposed to get under the Act. So Amanda, maybe you can tell us a little bit more about what your thoughts are.
That is such a good point about the records of the owners corporation, because I think in our Act it's around section 187, 189, something like that, without looking it up. It's kind of any document, I think it says.
Yes.
So is this then a document? That is a really interesting question. My understanding is that there are unique platforms that are set up. I don't know whether that's through a My Boss or a similar, that's not Facebook, that allows some interaction. That I think is going to be a very different situation and perhaps more controllable than Facebook. But I do agree with you, Reena. I think it opens up buildings owners to trolling, if you like, and unacceptable comments and communications that are then very difficult to control and to deal with on that kind of a platform. So it's something that I do tell people to stay away from, but that's not to say there aren't dedicated software programs that will do that for you. And actually, I spoke to Trent Muffet on the podcast last week about the Soho app, and that's something that they're looking at introducing for strata buildings who are then connected to the app, and it can be a one-stop shop for having all your documents, your records, and your group in the one place. So that's interesting. There are people working on that.
Yeah, but then, Amanda, this is the thing that I'm always asking myself. Then if people are putting documents and they're not sending it to the strata manager, then how are those going to be captured for a strata search or for a third party? I mean, this is what I find. If people start using those platforms, which are very conducive and are very effective in terms of keeping communication lines open, and it's easier to access documents, then what I find sometimes is that the manager then is sort of left out of that, or do they have to then go in and get the document out and then put it on their system, or do they have admin rights? I don't know how those things will work in conjunction with having something that all owners can access, whether they're on that platform or not.
Yeah, and something that's all connected, I would like to think, to your management system. And when you're putting in emails and you're putting in records, so I know in your office you use, say, a Strata Max, and just adding a group functionality to that so that everything is in the one system. I think that's probably the only way effectively that it could be done.
Yeah, exactly.
Now, I'm just looking at our comments box here. Precise Property is here. Hello, hello. Amanda, do you have the special resolution bylaw for bathroom renovations. Precise, we do have a template on the website that is specific for renovations, so lot owner renovations. It doesn't specify bathrooms, but any renovation that you need a bylaw for, you can use that template bylaw and just specify the work in the section of the template that calls for that. If you are a member, that template is absolutely free for you. Otherwise, they are $147 on the website. So check that out if you haven't already. I'm not sure if you're a member, but if you are, log on in and get your free template. Precise is also saying, owners think managers have access to this, the Facebook page, and they log repairs on the Facebook page, and then they get upset with us because we don't do the repairs. There we go. Thanks.
Exactly.
Yeah,
I'm actually so glad
true.
to hear that. Yeah. So I mean, I never would have thought someone would have put a repair on Facebook, but there you go. You can never really understand what people think that the platform's doing and how it's interacting with the Strata manager.
Yeah, absolutely. It's an issue. Well, Reena, I think you and I are both committed to this mandate, which we have given ourselves to better educate and inform and guide Strata communities. And I am so privileged to have you by my side during that process. And you are just going ahead in leaps and bounds with your business, Strata Central. I have the privilege of being sitting my office is very close to yours, let's say that, and seeing what you guys do every day. You are just heroes to me. I always say Strata managers are my heroes because you have a really tough gig, but you're doing a really great job.
Thank you. Yeah, it is. I mean, for managers out there that are listening, I mean, there are so many things we have to do in one day, and and sometimes in anything you've got your day plan, and the next minute something happens, and then you've got to drop that, and just, I think that there's so many competing demands that on a Strata manager's time that, you've got to learn to try and prioritize and not burn out, which I think is another thing that managers face, a lot of burnout, long hours, meetings, etc. So, yeah, thank you, Amanda. I appreciate that.
And thank you for prioritizing us today and for being here. All right, I'm going to switch off your camera if I can work out how to do that, and then give us all a quick wrap up. Thanks, Reena. Bye-bye.
Thanks, Amanda. Bye.
And if I do that, yes, here I am. Thank you, everyone, for being with us here today. Thank you for all of your comments. It's been wonderful, wonderful to have this chat, and I hope that we were able to get through a few more of those questions that you raised on the webinar, and thank you for adding those questions to the comments. You know that this video will just help so many people. I want to remind you that the doors to the membership are open. They just opened up yesterday. They are not open all the time. I only open them on special occasions, and now is the time to get inside the membership. If you like what Reena and I are providing here on these videos, and you have your pressing Strata questions, your issues that you need to get solved, then the Q&A forum inside the membership is absolutely the place to do that. So that's over at yourstrataproperty.com.au/membership. And you need to get in before Sunday night, midnight. I am closing those doors again. I'm a woman of my word. I promise the doors will slam shut at midnight. I've still got Reena there on the mic. I love this giggle. There we go.
Man,
there
I
it is.
say one thing. I just want to add one thing.
Let me bring her back on. She's back.
Sorry. I wanted to say to your listeners today that the value for YSP is immense, because there are so many templates and bylaws. To get a bylaw drafted by a lawyer is 3 times the cost of just being a member. So I think if you just need one thing done, you've saved money just straight away. So I think in terms of assisting you as an owner, as a resident, any members I suppose tenants can be members too if they want to.
Absolutely.
I suppose
We definitely have tenant members. Yeah.
Yeah. So it's wonderful, Amanda. So I think I just encourage all people to think about joining if you're not already a member, because the value is so much more than the cost.
Excellent. Thank you so much, Reena. And thank you, everyone, for being here. We're never too far away on this page. So we will thank you for all those love hearts and smiley faces. I can see them all popping up. We will catch you all next time.